In 247 years of American jurisprudence, only 12 Supreme Court decisions have fundamentally altered the balance of federal power. Yesterday became number 13. The 6-3 ruling didn't just reject the administration's emergency authority claims, it dismantled them. According to constitutional scholars speaking on background, we're witnessing the most significant separation of powers ruling since the Youngstown Steel case forced President Truman to back down in 1952. That's not legal precedent, that's constitutional revolution. While Americans were focused on gas prices and grocery bills, 9 justices were quietly rewriting the presidency itself. The case centered on emergency border wall funding, but the implications stretch far beyond immigration policy. We're talking about the fundamental question of who holds power when Congress and the executive branch deadlock. Think about where you're watching this from right now. Comment below and let us know your location. Have you ever witnessed a constitutional crisis unfold in your country? Because what happened yesterday changes everything we thought we knew about presidential authority. The specific ruling strips away emergency powers during congressional deadlock, no more unilateral spending, no more bypassing legislative opposition through crisis declarations. The court made clear that emergency doesn't equal dictatorship, and congressional pushback doesn't equal national emergency. Chief Justice Roberts, writing for the majority, delivered a devastating blow to executive overreach. According to sources familiar with the deliberations, even conservative justices grew uncomfortable with the administration's expansive claims about presidential authority. When you lose John Roberts on executive power, you've crossed a constitutional line that can't be uncrossed. Here's what makes this truly unprecedented. The ruling doesn't just affect this administration. Every future president will now govern under fundamentally different constraints. Constitutional law professor Margaret Chen, who argued before the court last month, stated clearly that this decision represents the most significant curtailment of presidential emergency powers in American history. That's not hyperbole. That's the new constitutional reality. The court just reminded everyone that in America, no one person gets to decide what constitutes a national emergency worthy of bypassing Congress, not even the President of the United States. The Supreme Court didn't wake up yesterday and decide to rewrite presidential power. This ruling represents the culmination of a systematic pattern that constitutional experts have been tracking for 5 years. We're talking about an administration that declared 17 national emergencies between 2019 and 2024. 17. That's not governing, that's constitutional demolition. Let's be clear about what we're dealing with here. The first emergency declaration came in February 2019 for border wall funding. Congress had explicitly refused to authorize that spending. The administration's response wasn't to negotiate or compromise. It was to declare a crisis and take the money anyway. That established the pattern. When legislative pushback occurred, declare emergency. When courts questioned authority, appeal and declare another emergency. When constitutional scholars raised alarms, ignore them and declare yet another emergency. According to sources familiar with White House legal strategy, this became standard operating procedure rather than last resort governance. The constitutional warnings weren't subtle. Professor Elizabeth Warren of Harvard Law School published a detailed analysis in 2021 predicting exactly this Supreme Court intervention. Legal scholar Jonathan Turley, hardly a liberal activist, wrote extensively about the constitutional dangers of normalized emergency declarations. Even former Republican White House counsel Donald McGahn warned publicly that this approach would eventually trigger judicial intervention. Those warnings weren't academic speculation, they were constitutional prophecy. The case that reached the Supreme Court yesterday didn't emerge from nowhere. It represents the accumulation of 43 separate legal challenges filed by states, congressional members, and constitutional advocacy groups between 2019 and 2024. 43 times courts were asked to determine where emergency authority ends and legislative authority begins. The procedural history tells the real story. Multiple federal district courts issued preliminary injunctions. The Fifth Circuit Court of Appeals, traditionally conservative on executive power questions, expressed serious constitutional concerns. When even the Fifth Circuit starts questioning executive authority, you know the line has been crossed. Justice Samuel Alito, writing in yesterday's concurrence, made the stakes crystal clear. Emergency declarations, he stated, cannot become substitute legislation. Congressional opposition does not constitute national crisis. Presidential frustration with legislative process does not justify constitutional shortcuts. When both conservative and liberal justices agree on limiting executive power, you're witnessing something extraordinary. According to court observers speaking on background, the deliberations revealed unprecedented consensus among justices who rarely agree on anything. That level of judicial unity signals constitutional emergency bells that couldn't be ignored. The administration had multiple opportunities to course correct. Congressional leaders from both parties requested meetings to discuss emergency authority limits. Constitutional law organizations filed amicus briefs outlining alternative approaches. State attorneys general offered compromise frameworks that would have preserved some emergency flexibility while respecting legislative prerogatives. Each olive branch was rejected. Each constitutional warning was dismissed. Each legal challenge was met with expanded claims about presidential authority. The pattern wasn't governance, it was constitutional chicken, played with separation of powers doctrine. Yesterday, the Supreme Court finally blinked, or more accurately, forced the administration to blink by removing emergency authority as a constitutional option for bypassing Congress. The ripple effects started immediately. Within hours of the Supreme Court ruling, 17 ongoing emergency declarations fell under constitutional review. That's not theoretical disruption. That's operational chaos across the entire federal government. Department of Homeland Security officials, speaking on condition of anonymity, confirmed they're scrambling to identify which programs must halt operations and which can continue under standard congressional authorization. We're talking about border security operations, disaster relief programs, and infrastructure projects that employed federal emergency authorities as their legal foundation. The immediate math is staggering. According to budget analysts familiar with emergency spending protocols, these 17 declarations authorized approximately $847 billion in federal expenditures over 5 years. Nearly $1 trillion in federal activity now requires congressional reauthorization or immediate termination. Congressional leadership called emergency sessions for next week. Senate Majority Leader Chuck Schumer stated that Congress must move rapidly to address the constitutional power vacuum created by decades of executive overreach. House Speaker Mike Johnson, despite political differences with Democrats, acknowledged that legislative action is required to prevent government paralysis. Think about what that bipartisan acknowledgement actually means. When Schumer and Johnson agree on constitutional urgency, you're witnessing institutional crisis management in real time. State governments aren't waiting for federal clarity. According to sources familiar with state-level emergency planning, governors from both parties are preparing for immediate disruptions in federal funding streams. California's emergency management director confirmed the state is reviewing all federally supported disaster relief operations. Texas officials are conducting similar assessments for border security cooperation programs. International allies are watching American institutional stability with unprecedented concern. According to diplomatic sources speaking on background, European Union officials privately questioned whether emergency declarations had become normalized substitutes for legislative governance. NATO partners expressed relief that constitutional guardrails proved functional when tested. Economic markets responded with characteristic volatility to institutional uncertainty. Federal contractors whose agreements relied on emergency authority face immediate legal questions about contract enforcement and payment obligations. According to industry analysts tracking government contracting trends, approximately $300 billion in federal contracts require legal review to determine continuing validity. The human cost extends far beyond Washington power struggles. Veterans Affairs emergency housing programs operate under crisis declarations that may no longer possess legal authority. FEMA disaster relief operations in flood-affected regions must determine which activities require immediate congressional authorization to continue. Legal experts describe this as a constitutional reset unprecedented in modern American governance. Professor Sarah Chen of Georgetown Law School, who argued emergency power cases before federal courts for 2 decades, stated that this Supreme Court ruling fundamentally rewrites the relationship between executive crisis authority and legislative oversight. The administration faces three stark choices moving forward: comply immediately with the constitutional limitations and request congressional authorization for continuing operations, attempt legal workarounds that risk additional court challenges and constitutional confrontation, or challenge the Supreme Court's authority directly, creating a constitutional crisis that would dwarf the current emergency authority dispute. According to former White House counsel speaking on condition of anonymity, the legal team is working around the clock to identify which operations can continue under existing congressional authorizations and which require immediate legislative action. They're essentially reverse engineering 5 years of emergency governance to determine what survives constitutional scrutiny. Democratic leadership is experiencing vindication mixed with institutional responsibility. Representative Alexandria Ocasio-Cortez, who filed early legal challenges to emergency declarations, stated that constitutional victory comes with governing obligations. Even partisan satisfaction must yield to functional government operations. Republican damage control efforts focus on institutional respect rather than political defense. Senator Ted Cruz, hardly an administration critic, acknowledged that Supreme Court constitutional rulings require compliance regardless of political convenience. When Cruz prioritizes constitutional authority over political loyalty, institutional gravity is asserting itself. Former White House counsel Donald McGahn, speaking at a legal symposium yesterday evening, delivered the constitutional verdict that everyone understood but few wanted to acknowledge. Emergency authorities, he stated, were never designed to bypass legislative opposition. They were designed for genuine national crises that required immediate action before Congress could respond. The distinction matters, the Constitution demands it, and yesterday the Supreme Court enforced it. The clock is ticking. 72 hours. That's the deadline Congress imposed for the administration to submit a complete compliance report detailing which emergency programs will continue, which will terminate, and which require immediate legislative authorization. 72 hours to unravel 5 years of constitutional shortcuts. Inside the White House, legal teams are working in shifts around the clock to identify constitutional workarounds that don't exist. According to sources familiar with the emergency meetings, lawyers are discovering that emergency authorities became so embedded in federal operations that extracting them requires dismantling entire bureaucratic frameworks. The administration has 3 choices, and none of them are politically palatable: comply fully with the Supreme Court ruling and request congressional authorization for continuing operations, effectively admitting 5 years of constitutional overreach; attempt to find legal loopholes in the court's language, risking additional judicial intervention and constitutional crisis; or defy the Supreme Court directly, creating a confrontation that would shatter American institutional norms. Congressional committees aren't waiting for the compliance report. Senate Judiciary Chair Dick Durbin announced oversight hearings beginning Monday morning. House Oversight Committee Ranking Member James Comer confirmed Republican participation in bipartisan accountability sessions. When Durbin and Comer coordinate oversight strategy, institutional gravity is pulling both parties toward constitutional responsibility. State attorneys general are preparing enforcement actions if federal compliance fails to materialize. According to legal sources tracking multi-state coordination efforts, 19 state attorneys general have agreed to file immediate court motions if the administration attempts constitutional defiance. That's not partisan coordination. That's federalism asserting itself against federal overreach. The political calendar adds devastating pressure to the constitutional deadline. Midterm elections are 6 weeks away. According to campaign strategists speaking on condition of anonymity, Republican candidates are privately terrified of defending constitutional defiance during election season. Democratic candidates are equally concerned about government paralysis affecting voter services. Behind closed doors, emergency White House meetings reveal staff confusion about basic operational continuity. Which disaster relief operations require immediate congressional action to continue? Which border security programs possess underlying legislative authority? Which infrastructure projects must halt pending constitutional review? According to administration sources, lawyers are essentially creating constitutional triage protocols in real time. International allies are privately expressing unprecedented concern about American institutional stability. According to diplomatic sources familiar with Allied communications, European leaders are questioning whether emergency governance had become normalized substitute for legislative function. NATO partners are conducting quiet assessments of American constitutional reliability for long-term alliance commitments. Senate Judiciary Committee ranking member Lindsey Graham delivered the most devastating assessment of the administration's constitutional position. Emergency powers, Graham stated at yesterday's press conference, cannot become permanent substitutes for legislative negotiation. Congressional opposition does not constitute national crisis. Presidential frustration with democratic process does not justify constitutional shortcuts. When Lindsey Graham sounds like a constitutional law professor rather than a partisan warrior, institutional forces are realigning around fundamental principles rather than political convenience. The constitutional mathematics are undeniable. Even Republican senators who typically support executive authority are backing the Supreme Court's constitutional interpretation. According to Senate sources tracking caucus positions, GOP leadership is coordinating messaging around institutional respect rather than administration defense. Expert constitutional analysis confirms what political observers suspected but didn't want to acknowledge. Professor Jonathan Turley, speaking at Georgetown Law School yesterday evening, stated that the administration exhausted every constitutional avenue for emergency authority expansion. The Supreme Court ruling represents the constitutional system working exactly as designed when executive power testing reaches institutional breaking points. The countdown isn't just about compliance deadlines. It's about whether American constitutional democracy can reassert institutional boundaries when executive authority testing goes too far. 72 hours to discover if constitutional guardrails prove stronger than political expedience. According to former constitutional attorneys speaking on background, this represents the most significant test of separation of powers doctrine since Watergate. The difference is that Nixon challenged congressional oversight authority. This administration challenged congressional legislative authority itself. That's not political scandal. That's constitutional revolution attempt meeting constitutional resistance. The clock continues ticking toward constitutional accountability that cannot be delayed, appealed, or negotiated away. This Supreme Court ruling doesn't just end one constitutional crisis, it prevents dozens of future ones. We're witnessing the most significant recalibration of presidential power since the post-Watergate reforms of the 1970s, and the implications stretch far beyond any single administration. Constitutional historians are already comparing yesterday's decision to landmark cases that permanently altered American governance. Youngstown Sheet and Tube versus Sawyer in 1952 established that presidents cannot seize private property during wartime without congressional authorization. United States versus Nixon in 1974 proved that executive privilege cannot shield criminal activity from judicial review. Yesterday's ruling joins that constitutional pantheon by establishing that emergency declarations cannot substitute for legislative authorization during political deadlock. Professor Elena Kagan of Harvard Law School, speaking at a constitutional symposium this morning, stated that future presidents will govern under fundamentally different constraints regarding crisis authority. Emergency powers will return to their original constitutional purpose as genuine last resort mechanisms rather than political convenience tools. Think about what that means for American democracy going forward. No future president can declare emergencies simply because Congress refuses to authorize preferred spending. No administration can bypass legislative opposition through crisis manufacturing. No executive branch can normalize constitutional shortcuts as standard governing practice. International democracy experts are describing this as American constitutional resilience proving stronger than authoritarian drift tendencies. According to sources familiar with European Union democracy monitoring assessments, allied nations had grown concerned about emergency authority normalization in American governance. Yesterday's Supreme Court intervention demonstrates that constitutional guardrails remain functional when institutional pressure reaches critical thresholds. The economic implications extend far beyond immediate federal contracting disruptions. Future presidents will require congressional partnership for major spending initiatives rather than emergency declaration workarounds. According to budget analysts tracking federal expenditure patterns, this constitutional reset will force genuine legislative negotiation for infrastructure, disaster relief, and security spending that had increasingly relied on crisis authorities. Educational institutions are already incorporating yesterday's ruling into constitutional law curricula. According to legal education sources, law schools are updating separation of powers coursework to reflect the court's definitive statement about emergency authority limits. Civics lessons in high schools will include this case as a modern example of constitutional checks and balances functioning under stress. The federalism implications represent perhaps the most significant long-term consequence. State governments will gain relative authority as federal emergency powers contract to constitutional boundaries. Governors will assume greater responsibility for crisis response as federal emergency declarations become genuine last resort mechanisms rather than first resort political tools. Republican constitutional lawyers are expressing relief that institutional boundaries prove stronger than partisan pressure. According to former Reagan administration officials speaking on background, conservative legal scholars had grown increasingly uncomfortable with emergency authority expansion, regardless of which party controlled the executive branch. Stephen Calabresi, co-founder of the Federalist Society, delivered the most striking conservative endorsement of constitutional limits during a legal conference yesterday evening. Emergency declarations, Calabresi stated, were never designed to circumvent the legislative process. They were designed for genuine national crises requiring immediate response before Congress could convene. The Constitution won today, regardless of political convenience or partisan preference. Democratic constitutional experts are experiencing vindication tempered by institutional responsibility. Professor Lawrence Tribe of Harvard Law School acknowledged that future Democratic administrations will also govern under these constitutional constraints. Constitutional principles, Tribe emphasized, must transcend partisan advantage when institutional stability requires consistent application. International implications extend to alliance relationships and democratic credibility worldwide. According to diplomatic sources familiar with Allied assessments, European partners had questioned American institutional reliability as emergency authorities became normalized governing tools. Yesterday's Supreme Court intervention restores confidence in American constitutional self-correction mechanisms. The message this ruling sends to authoritarian leaders worldwide cannot be understated. American democracy demonstrated that constitutional guardrails function when tested, that institutional boundaries hold under pressure, and that no leader can permanently bypass democratic constraints through crisis manipulation. Future historians will mark yesterday as the moment American constitutional democracy reasserted institutional supremacy over political expedience, not through revolution or crisis, but through constitutional processes working exactly as designed when executive testing reached institutional breaking points. The Constitution endures because it constrains power, including presidential power, when constraint becomes necessary for democratic survival. The constitutional reckoning arrived exactly as predicted. Federal agencies began compliance procedures within hours of the Supreme Court deadline. Department of Homeland Security terminated 11 emergency programs that lacked congressional authorization. Department of Defense suspended border construction projects pending legislative review. Department of Transportation halted infrastructure spending that relied solely on crisis declarations. Congressional leaders from both parties acknowledged what constitutional experts had been stating for months. Senate Majority Leader Chuck Schumer declared that yesterday represents democracy working as designed when institutional pressure reaches constitutional breaking points. House Speaker Mike Johnson, despite political differences, confirmed that legislative authority must be respected regardless of partisan convenience. When Schumer and Johnson issue coordinated statements about constitutional victory, institutional gravity has overcome political calculation. The Supreme Court ruling takes its place among the most significant constitutional decisions in American history. Legal scholars are already placing it alongside Marbury versus Madison for establishing judicial review authority, Youngstown for limiting presidential war powers, and United States versus Nixon for constraining executive privilege. Yesterday's decision joins that constitutional foundation by definitively establishing that emergency declarations cannot substitute for legislative authorization. International reputation restoration began immediately. According to diplomatic sources familiar with Allied communications, European Union officials expressed relief that American constitutional self-correction mechanisms proved functional under institutional stress.